Good evening, members. Apologies for the delay. We just got a slight problem with the webcast. So we're trying to sort it out. Good evening, members. We will now make a start. We think we're working, so hopefully it will all to be okay. Good evening and welcome to this meeting of the Planning Committee. I've been advised that there are no fire drills planned for tonight, but if the alarm does sound, Mrs Snooker, sitting to my right here, will ascertain the situation and provide further instructions. I would remind you that this meeting will be broadcast live and recorded for playback on the Maidstone Borough Council website. But will anybody else be recording or filming the proceedings? I ask so that people at the meeting will know if this will be happening. No? Okay. Members who are using mobile phones or tablets are asked to please ensure that these are on silent and are only being used with regard to the business on the agenda this evening. Okay, let's go straight to the agenda. Agenda item 1, apologies. We've received apologies for absence from Councillor Clark. Item 2, substitute members. Are there any substitute members?
I'll be substituting for Councillor Clark, Paul Wilby.
Thank you. Item 3, visiting members. Are there any visiting members? It's a silly question because I can see quite a lot. I'll go down this way. Councillor?
Yeah, Councillor Burton, just observing.
Oh, very good. Okay. Councillor Ford. Right. Councillor Springer. All right. So, Councillor Cummings, you're here just to observe, are you? Lovely. Okay, thank you. Councillor Bryce. Thank you. No more visiting members. Good. Okay. Agenda item 4, items withdrawn from the agenda. I understand that no items are recommended for withdrawal from the agenda. Item 5, date of adjourned meeting. If we do not manage to complete the business this evening, then the meeting will be adjourned to the 2nd of May. I hope we can finish with only 4 items, but you never know, famous last words. Agenda item 6, urgent items. I've agreed to take the update reports of the Head of Planning and Development as urgent items as they relate to matters to be considered at this meeting. Everybody happy with that? There's not an awful lot of items, actually. So. Good. Okay. Item 7, disclosures by members and officers. Disclosures? No? Okay. Disclosures of lobbying. What I'll do for each individual one, I think, because it's probably easier. And Russell here will remind me each time, so it'll be okay. Well, the image of Russell will remind me. That's okay. Good. Okay. Exempt items at 9. There is confidential legal advice, as you've all seen in yellow pages. I hope everybody's had a good chance to read this. I actually think the report is very comprehensive as well and covers the issues. Unless any member has any specific questions, I will propose, hopefully, that we don't have to adjourn for the yellow pages. But, of course, if a member really has wished to do that, then it's their right to ask that. Okay? Good. Thank you. Agenda item 10, minutes of the meeting held on the 6th of April. Are the minutes of the meeting held on the 6th of April agreed as correct record? Agreed? Agreed. Thank you. Agenda item 11, presentation of petitions. There are no petitions this evening, so we don't have to worry about that. Now, agenda item 12, deferred items. James, this is your chance to start.
Members will be very pleased that I reassigned that case again on the first item, 14504109, and the officer has told me that this will be coming to the next planning committee. So that will be on the next agenda. And I've got no further update on the second item. That is still ongoing. Thank you, Chair.
Thank you, James. Okay, so we'll go on to the agenda itself, the main items. You'll see there's a switch around here from the original index that was sent out. Now we'll be taking agenda item 16, which is the land at Woodcat Farm, Ashford Road, Hollingbourne, Kent. And that's page 56, and it's reference 15/503288 outline. I'll hand over to Richard.
Thank you, Chair. Good evening, members. This item relates to the outline application at Woodcut Farm that was refused by the Council last July and the subsequent appeal that has been lodged. The outline application was for a mixed commercial development of offices, light industry and warehousing with a maximum floor space of circa 46,000 square metres. Apart from access, all matters were reserved for future consideration, and as such, the Council was only considering the principle of this amount and type of development, and only the specific details of the access to the site. So the Council was not considering layout, appearance, specific heights, where buildings were going to be positioned, etc. The main report on the papers outlines that an appeal has been lodged, and it is usual practice for the Council to review its reasons for refusal and any material changes in circumstances. The report outlines how officers have reviewed the situation, taken legal advice, and are making 4 recommendations. The first recommendation, which relates to the grounds on which the Council refused the application in July last year, is the key decision for members this evening. The remaining recommendations relate to potential scenarios which may occur under the appeal due to changes to the Council's emerging policy and also any Section 106 agreement. In terms of the first recommendation, the report outlines why officers consider the grounds for refusing the application can now no longer be sustained, and thus to continue with those grounds would be unreasonable and would expose the Council to a very high risk of an adverse and substantial costs award in addition to the Council's own costs of defending the appeal. Recommendation 2 relates to the Council's position should the appellant apply to amend their appeal to accord with the Council's modified draft policy. Officers recommend the Council remain neutral. Recommendation 3 relates to a scenario whereby the appellant doesn't apply to amend the appeal or the inspector does not accept any changes should they be proposed. Officers recommend the Council objects to this because the proposal would not then accord or does not accord with the Council's emerging policy. Recommendation 4 simply seeks delegated authority to negotiate any Section 106 agreement. It's advised and has been agreed with the Chair that the recommendations be taken in their order. And again, clearly the key issue here is whether the Council maintains its grounds for refusing the application as it did in summer last year, and the others relate to potential scenarios in the Section 106. Thank you.
Thank you, Richard. Do you want to comment?
Thank you, Chair. As Mr Timms has just summarised, and as members will be aware from the main report and the legal advice, officers are advising that the grounds of refusal cannot be sustained at appeal and would have significant cost implications for the Council's budget. The Council's Director of Finance has confirmed that significant cost implications for the Council's budget currently stand at £30,000. Members have been informed that the bespoke inquiry is scheduled for approximately 10 days and potential costs, were a cost award to be awarded, could be very significant. For example, just to give members some examples in terms of recent cost award, we had a cost award for wind chimes for 10 dwellings, and that was a fuller cost award, and that was awarded against the Council with a submitted cost totalling £25,000. This was for half a day hearing with a junior barrister attending, and that was just for appellant's costs. Another example, the Old Stations Goodyards, which 66 dwellings, is a partial cost award against the Council, submitted cost totalling £80,000 plus VAT, was a one-day hearing with a QC, and that was just the appellant's costs. And with regard to the Council's costs, with a recent example, Waterside, the cost of defending the appeal by the local authority was £83,000 for a 10-day inquiry, which excluded the planning officer's support and in-house legal attendance. This excluded the appellant's costs. So overall, and taking into account the above examples, it is estimated that costs were an award to be made, and including the Council's cost in defending the grounds, could be in the region of approximately £350,000 to £450,000. I know members are no doubt clear on the cost implications. However, I am reaffirming this point, and this is a requirement under the Council's constitution. Thank you, Chair.
Thank you, James. I'd like to call upon Councillor Bennett of Hollingbourne Parish Council.
Well, first of all, many thanks for allowing me to speak on behalf of Hollingbourne Parish Council and, I say, many other local organisations as well. Obviously, this is not an easy matter, but we felt at the time, and we still feel, that every effort should be made to oppose the original proposal. I have no wish to return in detail to the original refusal, but it seems that road safety should have been mentioned as we were dealing with access. This location, whatever the highways people say, is dangerous. It involves a fairly steep descent from Maidstone to Ashford direction, followed by a sharp right-hand bend. And you do wonder if the Highways Authority would even regard playing chicken on the motorway as dangerous. Whatever you decide tonight, it does appear the planning officers have already handed Roxhills the advantage in expressing their concerns about being able to deal with the developer's appeal. I seem to recall you, Mr Chairman, had calls to remind the planning officers that they are the servants of the council and not the elected members. And I would like to remind everyone here that is still the case. The planning department pressed hard for this to be approved at the first time of asking, too hard in the view of many, and so we will not be that surprised at this latest turn of events. Unfortunately, in the workplace, you sometimes have to follow the boss's wishes, even if you disagree with them. If you feel unable to carry them out, one would normally expect you to, as the saying goes, consider your position. And we must ask, is this unwillingness to follow orders, and that's what it amounts to, a one-off, or will the Planning Department use this device to undermine the democratic process and repeat this stand if the committee refuses an application the planning officers recommend, therefore inviting and perhaps even encouraging an appeal? Once you set a precedent, it is very hard to stop it happening again. To fail to follow a fair decision reached by the Planning Committee would set this serious precedent, one at which the less scrupulous developers, and I don't include Roxhill among that, would rub their hands with glee. Forget the worry that the officers may be facing bigger boys with deeper pockets. Solicitors and barristers are not only overpaid, they're also overrated. Bosses sometimes make things difficult for employees, but that's life, folks. Get on with it. And if you can't, there's one really good piece of news. The job centre is within walking distance.
Thank you, Councillor Bennett. Councillor Springett, please.
Can I just firstly say I'm speaking on behalf, obviously, myself, Councillor Garton, Councillor de Wigendine, who's on his way from work, and Councillor Cumming. Good evening, members. I'm disappointed to be here once again trying to defend Woodcut Farm from inappropriate development. We do acknowledge that if the local plan is ultimately adopted, with Woodcut Farm remaining as an employment allocation, that this bit of rolling Kent countryside is going to be concreted over in the near future by some form of development. But to lose this land to this obnoxious warehouse-style proposal rubs salt in the wound. We acknowledge the current situation, but we still object to any development in this sensitive location. It is very sad that the rural approach to Leeds Castle, and also one of the main gateways into Maidstone, seen by many foreign tourists as they arrive in our country, is going to be sacrificed to meet an assessed need for employment land. Eclipse Park never fulfilled the supposed need we were all pressured into accepting several years ago. It's in a similar location, right next to a motorway junction, but what a hodgepodge development that has become. So yet more of our countryside will be lost under the guise of a perceived benefit. Huge grey-green boxes, no doubt emblazoned with company logos and nighttime floodlighting. The current proposal is awful. It will become one of Prince Charles' famous carbuncles if allowed to be built in its current form. This is why the appeal must be defended with all our might. Maidstone Borough Council must stand firm and rigorously uphold the correct decision the Planning Committee made last year. Rolling over in an act of submission in the desperate hope the applicant will submit a better design is not acceptable, and a clear message needs to be sent. Not defending the appeal to save money is not the way to go. Maidstone Borough Council spent well over £1 million to defend this site against the KIG proposal because of the harm it would have caused. That was the right decision. The sensitivity of the landscape has been confirmed by the 2 KIG inspectors, the Waterside Park inspector, plus a High Court judge. That is why the planning application was refused by this committee last year. The landscape hasn't changed, so why won't we fight to protect it from inappropriate development? The current proposal was submitted too early. It totally fails to meet the aspiration of the prestigious development in a parkland setting sought by the site policy criteria, which are being strengthened in the proposed amendments currently out for consultation. Members, I ask you to stamp your feet, uphold correct democratic process and say no to recommendations 1 and 2 before you this evening. Thank you.
Thank you, Councillor Springett. Councillor Fort, I think, is next.
It's clear in my mind that the proposed development is totally unacceptable for this site, and that is why the Planning Committee made the correct decision and rejected the application. We have fought 2 successful appeals, Kigg and Waterside Park, which consisted of similar warehouse development. So why now is it recommended that we throw in the towel and not defend the appeal? In not defending the appeal, we are sending out the wrong message to the people of Maidstone, and it shows a disregard of the normal planning process by not upholding the decisions of the Planning Committee. That's all I've got to say.
Thank you, Councillor Ford. I have no more visiting members, I think, who wish to speak. So before we go on any further, can I ask, have you all been lobbied? Has everybody been lobbied? I think that probably is the straight answer, isn't it? Good. Okay, so I think that's unanimous. Oh, yeah. There is an urgent update as well, which I've been reminded of, so just to remind you on that one. Okay. I'd like to call upon Councillor Prendergast, please.
Thank you, Chairman. I'd like to thank all the speakers thus far. They were interesting presentations. I'm a little surprised that there's no one here to speak for this item. Everyone's spoken against it. Before I go into it itself, I just want to record my dissent at the Yellow Papers and the way that they've been presented to us. We are elected members here, and that means we are charged with governing with the aid of officers, and this normally works really, really well. But the way these Yellow Papers have been presented to us in this instance, where they've been individually named, seems to suggest some sort of mistrust in this relationship, and I don't think this sits very well for this council and sends out the wrong messages. Well, it certainly does for me. And I was going to ask for an explanation. I'd like an explanation from the leader of this council and also our chief exec on why they were presented to us this way. It really is not a good way to do it. Regarding the Yellow Papers themselves, there are all sorts of anomalies contained within them. I'm just going to make reference to a date, that's all, a date. There is something about the committee having made a decision in August 2017. Well, I'm not projecting my future, but we haven't reached August 2017 yet. And that, I think, is at paragraph 83. Okay. And also, whilst we're at it, for the sake of consistency, I would like, whatever the decision, however the decision goes tonight, for the sake of consistency, I do think that we should have a named vote. This is how it was done the last time. And I think, for transparency, it's better to get named votes for this. Okay, my questions then, or my comments. I was going to ask about cost implications, but Mr. Bailey has updated us on that, so there is not too much to say on that, other than, as Councillor Springett pointed out earlier, and others have pointed out, the predicted cost implications for Waterside Park did not necessarily arise. You know, we were given the same warnings at the time, and the High Court challenge also was unsuccessful. What I'd like to ask officers here is, why have we not addressed the option that is the value of waiting? If members wish to withdraw or not defend the appeal, why can we not wait until the findings of the consultation on the main modification to the local plan and the local plan inspector's final findings are revealed to us? The public inquiry isn't till October, so we have time on our side. We can wait for these findings to come in and then choose to withdraw or not defend. So waiting actually has a value that we should consider, and we don't seem to have done it in this instance. I'm just looking at the recommendations. To agree, it makes reference to the sole reason for refusal. Well, in my mind, there are two reasons for refusal. First one is harm to the countryside and the landscape, and the second one, heritage assets. I actually took the liberty of viewing the webcast from the 30th of June last year, and it was quite interesting. And those words, the decision notice, those words were actually framed by the case officer at the time, and I can recall the words, that the officer saying to us, these words would be considered sustainable at appeal. So what has changed now? Surely these grounds can still be defended. There must be relevant policies in our current local plan, the emerging local plan, the MPPF, that we can utilise in this instance. There's got to be. Regarding heritage, we had the Conservation Officer here in June last year, and he supported that. So we have, I can see that that is absolutely defendable. We had, I think, reference to the Forest of Dean case law last year, which, let me get this right, which sort of identified that paragraph 134 of the MPPF is a restrictive policy and sort of therefore disengages the presumption in favour of development. So nothing has changed in that instance as far as Woodcote Farm goes. Regarding material changes since that decision was made, when we were asking for this legal advice, when we wrote the officer's report, when this officer's report was written for this evening, did the officers specifically ask for the implication of ED 118, consultation for the local plan, and the fact that it means that the local plan inspector has not made any final decisions? Did they actually consider that, or did we just ask for clarification with regard to the interim findings? Because clarification on that would be really helpful, because I don't believe that the inspector's comments, that consideration should be given to safeguarding part of Woodcote Farm or other sites suitable for office developments from other users for a period pending a recovery of office development values later in the plan period. I don't believe that that is an endorsement that the site should be included in the local plan. And obviously, we're still waiting for the inspector to make his decision. There's just one more point I want to make, please. Also, when taking this advice, was the issue of the mismatch between the site assessment exercises and the allocations sought? Because it's my understanding that there were many sites that were rejected from the exercise, and Woodcote Farm was chosen. And I think 9 or 10 of these performed significantly better in the exercise and had a combined yield of over 5 times the yield of Woodcote Farm. So have we actually considered, when taking this legal advice, that it could be open to legal challenge? It's something that the Rule 6 parties or other interested parties might pick up on as far as the local plan goes. And also, just finally, and this was just an afterthought at the very end, given the inspector's comments about this site and really what I'm trying to say is there's no mention in the officer's report or the application about the need for a Leeds-Langley bypass. This is clearly a major employment hub at this location, and we're looking at access here, so we do need to address how we are actually going to get people to and from this location. That's all I've got to say at the moment, but I'd like to reserve my right to come back, please. Thanks.
Thank you, Councillor Prendergast. Before Councillor English, I'll give you a chance to comment. I think there's a lot of questions you raise, but we must stay to the point on this. You must stay to the point.
Yeah. Can I?
Go on, yeah.
Yeah. Thank you, Chairman. I was just going to respond from a local plan perspective. But to summarise, Maidstone Borough Council, in effect, well, not in effect, Maidstone Borough Council, as a full council, approved the local plan going forward to examination. And I defended the local plan along with my team throughout that examination. But getting back to the point here, in the local plan that was presented to the inspector presiding over the examination in public, we said that we needed to provide for X square metres of B-class employment space in the borough. And this is by far our largest site. There are other sites. So, to my mind, there's two things. We're saying that we need to provide for X square metres of employment space, and this is our main strategic location. The other sites, like the site outside Headcorn and Marden site, are much, much smaller. So we said to the inspector, I said to the inspector, that we are accommodating our B-class employment need primarily at this location. I'm not aware of better locations at this size, elsewhere in the borough. And I've been involved in the Junction 8 area for probably coming up to 5 years now. And we have looked throughout the borough for suitable sites. In my view, with regard to the examination and using examples, when the inspector did not like certain allocations, for example, Syngenta, he said at the examination, I do not think this is acceptable because of flooding grounds. In the interim findings of the inspector, I can think of 2 sites in Bourton Lane where he said, because of highway safety issues, I advise you to take them out of your local plan, and we have done so. What has happened on this site, and it happened during the examination, the inspector said, Maidstone Borough Council, you have a need for 24,600 square metres of office space. At the time, midway through the examination, he was unhappy that we were accommodating that 24,600 square metres, that we didn't have enough sites. And you will see in Mr. Timms' report that we are following his advice, that we have doubled the office and research and development square meterage from 5,000 to 10,000 square metres in our policy, which is out to consultation now, as you quite rightly said, Councillor Prendergast, and that it's phased as well. Thank you.
Just briefly, Councillor Prendergast raised the issue with why make the decision now and wait. As outlined in the report, there is an agreed timetable. The Council needs to submit its statement of case on the 4th of May. That's the second time that's been extended, which hasn't always been agreed by all the parties, if I'm honest. We need to tell the Planning Inspectorate what our position is, and we can't wait to decide what that is. We need to be clear, and as the report outlines, we are advising members of the situation and to take that position as soon as possible to avoid costs. I think on the interim findings report, and Mr. Jarman has touched on that, the purpose of that report was to identify any changes that were required to make the plan sound. As Mr. Jarman said, the inspector's not indicated that that policy must come out and refers to it as providing or needing to provide more office space. There was additional work, I think, reference to ED 118, which was essentially looking at commuting patterns, employment land provision for Maidstone and 5 adjoining boroughs. That work was carried out, that was submitted to the inspector, discussed, parties were given the opportunity to comment on that. If the inspector had considered that Maidstone needed to do more work on that point and look to other boroughs, he had to say so, and he's not said so. So our view is that that does not alter our view on the interim findings. And in terms of, yes, there is a public consultation which is currently being carried out. That is on the modifications to the policy. It's not on the principle of the site allocation. So it's on Maidstone's proposed modifications to that policy. That's all I had to say. Thank you.
Councillor English, please.
We need to be clear what we can and cannot do. Although I have sympathy for many of the arguments put forward, we cannot, should we decide to defend the appeal, change the grounds of refusal at this stage. So whatever people argue about certain issues of whether other sites should have been explored or not, or whether or not there are highways issues or issues of this or that, the grounds of refusal are the grounds of refusal. We cannot legally go away and say, no, we should have put this in. I can think of several things we probably should have put in, but it's too late. We can't do that. So that's point one. Secondly, I must say that as a member of this council, I think we should be aware that it is the officers' job to make their best use, their professional judgment, and to put that argument forward. As a planning committee, as members, we may violently disagree with that professional judgment and come to a different weight. But it is not acceptable for anyone, whether they're the public, parish council or members of this council, to say that officers should not use their professional judgment, which has been said this evening in effect. And that is unacceptable. It would not serve the public or us well if officers started to be afraid of giving us their best professional advice. Thirdly, the situation with this and some other appeals is somewhat different in my view. I was in the chair when the officers recommended approval of Waterside Park, and I moved the refusal of it. But I would have to say that the grounds for refusal, what we used for Waterside Park, were much more specific to the actual harm that would have been done by the application. The problem we've got here is essentially we had an outline application. So those speakers tonight who have talked about the harm that the development would do are actually in a slightly difficult position, because the applicant, rather cleverly, like a lot of applicants over the years, put forward an outline application which really, apart from the access, didn't really have confirmed details. It had an indicative scheme. So we are actually not being asked at that point to judge the specific harm. So because the proposal was outlined and there wasn't a way of judging that. That doesn't mean we couldn't have turned it down, but we would have had to frame it in different ways. And what we didn't. What we actually decided to do, because it was an outline application, as a committee, was to turn it down essentially on the principle without defining in any way what the actual harm was. That's a bit of a problem, because we started, when ENV 28 and other policies in the 2000 local plan were written, they were essentially policies of principle. But, unfortunately, the planning framework has changed a great deal over the last 15 to 17 years in its various iterations. And it has now become the case for the MPPF, and yes, the Forester Dean case properly interpreted, that a threshold test of harm is effectively in place. So you can't just say, no, it's actually unacceptable. Even with landscape policies or conservation policies, you have to actually say, at least to a certain extent, what the harm is. And we didn't. So going back and examining that now is actually quite difficult. We could try, but I have to say that we have to focus on, if we are defending the appeal, on what we can do and not what we should have done or what we might like to have done, or interpreting planning rules and policies in ways that help us rather than what they actually are in law and in planning regulation. Because if we start making intelligent guesses or unintelligent guesses or being creative, it isn't going to work. So we have to, if we are going to defend this, be absolutely sure that we can defend it on the grounds that we actually used and against the planning policy background that actually exists, not some imagined interpretation of it that we'd like to exist, because that is frankly where we are at the moment with some people. And I reserve my right to come back, but we absolutely cannot just say that this is unpopular, therefore we should maintain our position, because I'll tell you what would be really unpopular is if we go to an appeal, lose it, and this application happens anyway, we have to think very carefully about how we defend this if we can defend it, and not just go on the basis that that will make us unpopular in certain parts of the borough.
Thank you, Councillor English. Councillor Harwood.
Thank you, Chairman. I think we all understand that it is absolutely inevitable that the Council's case at the forthcoming inquiry will collapse under its own inherent contradictions. The Strategic Planning Committee and the full Council voted in favour of an allocation of the site. An outline application delivering upon the democratic will of the Council was rejected. There is often a real and an understandable confusion in the mind of the public about what Planning Committee can do. The Planning Committee think we can just say yay or nay and we can refuse because we don't like something. We cannot do that. We are a regulatory committee which interprets policy, national policy, which has never been more pro-development than it currently is since the Planning Act was introduced, since the late 40s, is one part of the background. But the other background, which is hugely important, is the local planning background. And, I did not vote for the local plan, but week after week, I'm coming back and I'm supporting allocations in the local plan because we have no choice. What the Planning Committee does is it does have greater control over anything which is outside of policy, and it is able to negotiate improvements through emphasis upon policy in terms of the quality of development. It cannot throw out an allocation because it doesn't like it, particularly when it is an outline, where there is no detail on design, there is no detail on materials and so on, all of the sorts of issues where we can have some input. In relation to Waterside Park, I was a witness at the appeal. I was cross-examined at the appeal. I was in the stand for a very, very long time, and that was defensible. It was defensible because, one, it was not a local plan allocation, and because it was not a contained site, therefore the potential for that development to spill out into the surrounding countryside, the beautiful countryside to the east of Maidstone, up to the Green Sand Ridge, was real and present. It was not a site cut off by a motorway, an A road and a motorway link road, and therefore has the enclosure. One of the other reasons why I was so tenacious in fighting, and I think I was cited in the reason why it went to the High Court as well, so I was quite involved in that particular appeal, was that I saw it as a Trojan horse for a Leeds-Langley road, which would inevitably destroy our beautiful countryside because it would open up countryside which is currently undeveloped to untrammelled development, just as what the landowners want, and the siren voices wanting a road through that countryside need to think a little bit about you know, why that road was required, and the amount of development that would fund it and the amount of development that would follow it. However, in this case, you know, the framing of the grounds for refusal, the decision in full council, and the decision before that of the Strategic Planning Committee they give us no choice, but we have to you know, take that neutral position at the appeal. The others will fight that appeal, and they will do it with whatever their evidence is. But we cannot, because of all of the reasons, the legal reasons which we've been confronted with, and mainly it's because we're a regulatory committee. We're not a policy committee. So on that grounds, I'd actually move the officer's recommendation on the papers. Thank you.
Recommendation 1 is that, Tony, not all of them.
It's recommendation 1. Yeah. Does anybody else wish to speak, members? Oh, it's quite a few. Seconded? Oh, second. Yes, good point. Is there a seconder to that? I thought you, Councillor English. Okay. I saw 2 hands go up to speak. Councillor Borton?
Thank you very much, Mr. Chairman. And it's clear that the officers have made their mind up on this by the report we've got in front of us. But at the meeting last June, I specifically raised the questions, Mr. Jarman, I think it was at the time, about where what carried greater weight, basically. Was it the existing 2000 local plan? Was it the draft local plan? And I came to the view, based on the answer that Mr. Jarman gave me, that more weight was accorded to the existing policies in the 2000 local plan rather than the draft local plan. 6 others came to a different view, and 7 of us came to that view. What's changed then is obviously we've had the examination. And of course this is only an interim report, and though a detailed interim report nonetheless. But I take the view personally that this is still possible. I think we've heard tonight some of the arguments for that. There's clearly a lot of people working very hard on this, and this is a very, very sensitive site in an important strategic location for the borough. And my personal view is to come to a different view to Councillor English and Councillor Harwood, that this can be fought at appeal. I look at the framing of that fin, and yes, perhaps there are things we'd have perhaps added in due course. Hold on, Councillor English, I've got the floor here, so I shall finish. Okay? I didn't interrupt you, so don't interrupt me. So, where was I? So I come to a totally different view, okay, than Councillor English. I think it's very important here as a planning committee. Yes, we are a quasi-judicial committee. We do have regulations, but the people voting on this are all elected by our respective communities across the borough here, and we have an obligation, even on the planning committee, to listen to what residents are saying to us. And residents are saying loud and clear across the borough that this is a decision that we must defend, that we must go to appeal, and ultimately I always try and listen to those to planning officers' professional judgments, and I'm not denying that they've come to this view, but I'm also balancing that up with what residents are saying too. And it's terribly important that we do that, as all of us do that as elected members, rather than just coming to our view prematurely. So I'm afraid I take a different view, and if that's been moved by Councillors Harwood and English, I'll be voting against it. And finally, I would support Councillor Prendergast's call for a named vote, and I think you need a third person to do that to ensure that happens.
Councillor Stockwell, I think, did you want the floor?
Yes, thank you, Chairman. Well, I totally agree with the 2 ward members that spoke earlier, and indeed Councillor Burton and Ms Prendergast, and disagree with Councillor English. This is a very sensitive location. It always has been. It's always been something that we've tried to protect down the years. A huge impact it will have on that location, on the views to the AONB and from the AONB, the special landscape area, all the rest of it. These are quite substantial, large shed buildings to me, 15 of them. As I said, some are double stories and big. I mean, they're going to have a huge impact. I know this is outlined or whatever you said at the beginning, but that is what is intended there, and I think we've got to be very, very careful that we get the right building there, the right sort of quality, and not just a B8 storage distribution and all the other bits. I know there's other B2 and B1 as well, but it's going to be quite intensive. So I really think we should, and what's the point of refusing an application if we're not going to defend it on appeal? I totally support that we should be defending this on appeal. The public expect us to, and then they expect us to spend money on it, and quite rightly so. That is what we're here for, and frankly, the officers don't want to, the members may want to. So my answer here is we should be defending the appeal and making sure what goes in that location is what the public want, and it should be a sensitive, nice development. Thank you.
Thank you. Councillor English, I think you asked the floor again.
I would have to say that personally, although it is within the council's procedures, it is outrageous to use a name vote on a planning application. It is nothing more than a naked attempt to intimidate members of this council into voting in a certain direction, and frankly should not be imposed on this. Members of this committee are supposed to use their judgment, rightly or wrongly, and they should not be criticised for doing so, whichever way they vote. The use of a name vote is primarily within the council for issues of political controversy. It is being misused here. Secondly, I do apologise, Councillor Borton, for interrupting you. It was wrong of me, and I should not have done it. I may have misheard you. I would point out that if we defend this or not, we cannot add anything. We can take things away, but we cannot add anything to the grounds of refusal. Now, that's not to say we shouldn't defend it. I'm just saying we cannot add anything because the grounds we used at the time were the grounds that will have to be defended at the appeal. The only thing that could be varied is if, the applicant comes forward as part of the process with a variant application, but that isn't what we're considering tonight. That's a different scenario. So, finally, members of this council, yes, do have to listen to the public, but primarily we are supposed to use our judgment. And I've been involved in planning a very long time. I'm not always right. I've got things wrong. And I remember arguing very vociferously that we should defend an appeal decision in Tovel many years ago, Hale Mill. And the officers told me it was indefensible. And, I was wrong. I should never have forced that appeal defence to go ahead. It was one of the biggest mistakes I ever made. I did no service to my parish constituents by making that argument, by giving them false expectations, and basically it was a big mistake I ever made because I went against all the professional advice, the barrister's legal opinion, and decided that we should defend the appeal because that was what the public were telling me. It didn't work. It was a disaster. And on top of that, we lost control of the whole process. Instead of getting an application that might have worked, that we could have mitigated, we completely lost control of that, and the developer won every point on appeal. Finally, I would remind people, whatever we do, we are not determining a detailed or full application. It was an outline application. We don't know what the heights of the buildings are. We don't know what the design of the buildings are. That's the problem. If they come forward with that and they've been inappropriate, we could have turned it down on that. We could still, in theory, turn down a full or reserved right matters application if they come forward. So bear in mind, it's an outline, and we turned it down on the principle plus the heritage point. Yes, I agree with Councillor Prendergast on this point. I think it is 2 grounds of refusal and not 1. But, you know, it's in 1 paragraph, but it is 2 reasons, isn't it? I think we need to be clear about that. And those are the grounds we have to be confident we can defend. Nothing else comes into it. Just one final point. To ENV 28 and other policies under the local plan, they have to be assessed against the evolving policies in the National Planning Policy Framework. They have had a subtle effect on those policies. Yes, I agree. The policies in the 2000 local plan did take priority at the time, and still do to a certain extent, over the emerging plan policies. But they are influenced by subsequent planning policies, whether they're the Staplehurst Neighbourhood Plan, a very good document, or the National Planning Policy Framework. And they've changed the context. And we are looking at no longer an absolute prohibition on building in the countryside, although it has rowed back from the presumption in favour of development. Again, you were right on that point, Councillor Prendergast, to that degree. And it becomes a threshold test as to the actual harm that is being caused, or not, as the case may be. And that was the difference at Waterside. We could actually evidence very clearly the harm. We might have been able to do that with this application, but we didn't. And we can't go back and say, you know. So I rest my case, and I apologise for being a little long-winded there.
No need to apologise, Councillor English. I've got 2 more speakers, and then we'll sort out the vote. Councillor Powell, please.
Yeah, thank you, Mr. Chairman. I'm finding myself in a difficult position tonight because I seem to be agreeing with everybody, which is most unusual for me. I think there's been some extremely kind of interesting points being raised, but in my very, very basic understanding, nothing at all has changed since last year. We sat round this table, we had exactly the same conversations, and the only thing that I see that is different tonight is the members were not given a costs warning before making their decision. That is the only thing that has changed. And it's taken us since last July to come round this table again tonight to discuss costs. I thank you ever so much for warning us about costs, but as far as this table is concerned, I think we've got to look at the actual kind of issue itself. And I would just like to read it out. Everybody's read it, I'm sure, 2 or 3 times. But the proposed development will be harmful to the character and appearance of the countryside. Special landscape area and the setting of the Kent Downs area of outstanding natural beauty, and any benefits are not considered to outweigh this harm. It would also cause less than substantial harm to the setting of the Grade 2 listed building Woodcut Farm, and any public benefits are not considered to outweigh this harm. The development would therefore be contrary to Save Policies EMV 21, 28 and 34 of the Maidstone Borough-wide Local Plan 2000 and advice within the National Planning Policy Framework 2012. And yes, we have had an inspector's report since then, but I don't think that anything at all should change from what we actually spoke about and what we voted on last July. Thank you.
Thank you, Councillor Powell. Councillor Borton?
Yes, I've also come back on some things Councillor English said. I think he must have misheard me, because I did say in hindsight perhaps we would have added some more things to the reasons recommendation. But there's an important point on the principle of named vote here, and I take totally the opposite view, that we are councillors, we are representative people. Now, I actually believe that most of our votes should be named votes, so we can be accountable to the people who put us here, and so that they can very easily see that actually I don't like, Mr. Councillor Bloggs from wherever, I don't like the fact you voted on this and that, making it accessible. We can't dodge democracy, frankly. However much we might want to, or some people might want to, we just cannot dodge democracy. Of course, what we've actually got in front of us is some legal advice, and I'd stress the word advice there. What's very clear from the representations I've certainly received is that there is alternative advice suggesting something totally different as well, and we've got to consider that. Now, it's not me to say that the preparation from the councils is incorrect at all. What I'm saying is that you can assess the same issue and come to a different conclusion, and we see that on planning application after planning application, including this. But Councillor Powell is right. Of course, the only other thing that's changed as well is the inspector's interim report, and again, stress the word interim there. And of course, I covered this earlier as well, but this isn't. We're less than a year on, and yes, an awful lot does seem to have changed. So, all in all, we've got to remember that what we've got in front of us here is just advice, and we've got to consider that these issues will be thrashed out much more than us in an hour here. These will be thrashed out at a long 10-day appeal, and I take the view that there is sufficient evidence out there to defend this site from the development that's come forward.
Thank you. Before I give the floor to Councillor Mumford, you want a name vote. Do we have 3 councillors who will support a name vote? So I need to know, so there's a lot of hands going up. Are we okay with that? Councillor Stockwell.
Before we move on, Mr Chairman, may I have my dissent formally noted at the use of this process?
Of course you may, yeah. Councillor Mumford, please.
Believe it or not, I'm still midway. What I'm trying to weigh up here is the objection, and the framing of the objection could have been a lot better to give us a lot more power and appeal. But it is what it is. I've had the objection read to me, the words, but the important wording to me is what is written in EMV 21, 28 and 34. Also, what you're objecting to here is an allocation that has been voted on by full council that probably went through 3 years of scrutiny, and that was painful. We've got to consider the weight on EMV 2834. I agree with that. What has changed, we're now in an appeal situation where we can get costs. And as well as having a responsibility to those residents who are immediately affected by this development, we also have a responsibility to the remaining residents and the public purse, which is quite substantial. Someone said an opportunity to have the right buildings. Well, we get that when we get detailed and outline, and I'm still not convinced whether I can go forward and support this objection. The objection framing is poor. The EMVs, probably we should have used the emerging plan, which we did not, and we cannot add to it. And so when we get to appeal, if we decide to fight it, we only have that to fall back on. And remember, it's outline. I'm beginning to come to a conclusion, but there's a lot being spoken about, but basically it's the framing of our objection, the EMVs, balanced against the public purse, and whether you feel confident.
Thank you, Councillor Mumford. I'm going to ask the officers just to come back finally, then we will go to a vote, definitely. Thank you.
Thank you, Chair. Yeah, it was just a final point. Obviously, everything's outlined in the report, but there's just been mention of what's changed since the decision. It is outlined in the report, but following the decision, the Council did not take a decision to remove the policy from its local plan. Officers defended that allocation at the local plan examination. Officers consider that the interim findings does endorse the policy. The inspector has not asked for it to be removed, and that's on the back of additional evidence that the council provided. SPS&T committee endorsed those modifications, another step along the way. So that's what officers consider has changed significantly since the appeal was lodged. And what we're asking members is to make the decision based on the situation now and not what was done last summer. Thank you.
Thank you very much. Okay, we will now go to the vote. And I'll hand over to a legal advisor here who will handle this. Thank you.
Thank you, Chairman. Recommendation 1, to agree that the sole reason for refusal recorded in the Council's decision notice should not be defended on appeal. Councillor Borton, for or against? Councillor Cox, for or against? Councillor English, for or against? Councillor Harwood, for or against? Councillor Hastie, for or against? Councillor Hemsley? Councillor Munford, for or against? Councillor Perry, for or against?
Against.
Councillor Powell, for or against? Councillor Prendergast, for or against? Councillor Round, for or against?
Against.
Councillor Stockel, for or against? Councillor Wilby, for or against? 1, 2, 3, 4. That's 5, 4. 1, 2, 3, 4, 5, 6, 7, 8 against. Recommendation is lost.
Yes, you can, of course. Okay. Please, members, please. Rob, you want the floor?
Thank you, Chairman. Thank you, Chairman. In accordance with this Council's constitution and my delegated powers, this needs now to be referred to the Planning Referrals Committee.
Okay, we take that point and we move on to recommendation, the other recommendations. So recommendation 2, and we go down the same procedure. Before I do, is everybody clear on what we're voting on recommendation 2? Or do you want the officers to...
Mr. Chairman, can I confirm that recommendation 3 automatically falls?
Yes, it does. Yes.
Chair, can we just we'll come to that.
Yeah, okay.
We can do it recommendation by recommendation.
Yeah, we do. No, we've agreed to do that. Yeah, absolutely right. Okay, so recommendation 2. Carry on, Russell.
Thank you, Chair. Recommendation 2, to agree that the Council should adopt a neutral position in response to the appellant's proposed amendments to the appeal proposals. Councillor Borton, for or against? Sorry. Against. Councillor Cox? Councillor English? Councillor Harwood? Councillor Hastie? Councillor Hemsley? Councillor Munford? Councillor Perry? Chair?
Oh, sorry, please.
For or against?
Against, sorry.
Councillor Powell? Councillor Prendergast? Against. Councillor Round?
Against.
Councillor Mr Stockwell. Councillor Wilby. The vote is 5-8.
We go to recommendation 3. Do you wish to say anything on that? Yeah, Richard, please.
Thank you, Chair. Recommendation 3, in effect, would follow on if members had decided to drop their grounds for refusal. It was a scenario whereby if the appellant didn't amend the application, we would recommend you object because it's not in line with our emerging policy. So in officer's view, that now falls away and doesn't need a decision on. However, Mr Jarman will confirm recommendation 3 in officers' views does need to also go to the referrals committee because they relate to one another. So recommendations 1 has been indicated by Head of Planning and recommendation 3 would also go to the referrals committee.
Just to say, can I just confirmation on this? Are we required to vote on this? Not, presumably.
Well, if you did and you reached a...
No, because because of the decision in recommendation 1, it automatically falls. No.
So we just need general agreement that will fall, given these. Okay.
Do you want to take a vote on it?
No, we don't need to. I don't.
We will refer.
It just goes refers.
Make sure that's clear.
Yeah.
Russell, can you just confirm that will go to referrals?
Yeah.
Just to make clear, recommendation 3 will go to referral committee as well.
Okay. Right. Recommendation 4.
Do you want to?
I think that's all right. It's agreed. Yes, please, Richard.
Recommendation 4 is seeking delegated authorities for officers to negotiate. So even if we defend the appeal, we still need authority to negotiate. So that's what we're seeking here. Thank you.
I don't think we need a name vote for that, do we? So I think we're in general agreement. Action must be NEMCON. Okay, so it's unanimous. Yeah, thank you. So that's total agreement. All right.
Sorry, can we just do that? On recommendation 4, hands up if you're happy for the...
it's unanimous.
Yeah, I appreciate that. Just need to see it. Yeah. Thank you.
Good.
Just to clarify, recommendations 1 and 3 are going to planning referrals.
Everybody happy? Or not, as the case may be? Then we're completed. Right. Good. Right. Okay, we'll go on to the next one.
Mr Chairman, could I have just a couple of minutes break to go to the...
Please have two
of course.
flagons.